afternoon and a warm welcome on behalf of the CTO Forum and the 9.9 group to today's session on Digital Data Protection Act. The reason we are hosting this session is because this new law has the potential to significantly impact numerous businesses and IT processes across the enterprise, as well as organizational relationships with partners and stakeholders. The genesis of this law goes back to 2017, when the Supreme Court of India ruled that privacy is a fundamental right, and the right to privacy is protected as an intrinsic part of right to life and personal liberty. With digital technologies and services becoming a core part of every citizen's life today, there was growing concern about the need to govern and regulate privacy in the digital sphere too. After numerous deliberations and discussions, on 11th August 2023, the Digital Personal Data Protection Act 2023 became a law. So now we have a formal legal framework for handling, collection, storage, and processing of personal data in India. Now, a greater responsibility has been thrust upon all technology leaders to ensure compliance, especially because the DPDP Act envisages significant penalties for violations. Of course, compliance with the Act is not just about avoiding fines. It is also about building organizational trust with stakeholders and securing business value. The purpose of today's webinar is to learn from experts who have successfully navigated and managed similar regulatory environments and have greater knowledge of the potential challenges and implications of the Digital Personal Data Protection Act. To start off, let me invite our first speaker, Mr. Venkatesh Subramaniam, President and Business Head Cybersecurity at Mindsprint, an Olam Group company. Mr. Subramaniam is the CISO and Business Head of Mindsprint, where he is responsible for the cybersecurity of more than 250 locations, including 100 plus factories in 70 countries. He is also the head of Olam Group's privacy practice and has experience with data protection regulations across more than 40 jurisdictions across the globe. An engineering and management graduate, Mr. Subramaniam has more than 28 years of experience in information security. He has in the past worked in the finance and telecom sectors and with various Fortune 50 companies. He is also the recipient of several awards for information security and is on the advisory boards of various companies and awards juries. In his talk today, Mr. Subramaniam will cover the basic tenets of personal data protection, drawing on his extensive expertise as a practitioner. So over to you, Mr. Subramaniam.
Thank you, Giri, for the kind introduction. Welcome everyone to the webinar. I have a few slides, so let me share my screen. So basically, the Digital Personal Data Protection Act, it is a welcome and transformative step in personal data governance, underlying our collective responsibility towards a privacy-preserving and cyber-resilient world. The Act did, of course, have its share of starts and stops in its journey over the last several years, as Giri was mentioning. But it is here now, and it marks an important step in providing a comprehensive legal framework around personal data handling. So quickly going through, the journey of this Act over the last several years. Basically, in 2019, basically, in December, the bill was tabled, introduced in the Lok Sabha, and then at the same time, it was also referred to the JPC for a review. So after about 2 years of deliberation, the JPC came back, with recommendations and amendments. And what happened was that, in the middle of last year, in August, the bill was withdrawn, and primarily due to the number of amendments and recommendations that the JPC had proposed. So what happened is, then towards end of last year was the first draft, of the current, bill, which was released in for public comments, and then finally now in August, the bill has received the assent, and now it is an act. So that's been its journey. There is still a way to go. So while it is an act now, there are still pieces that still need to be put in place. but then that its journey will still continue. But this is an important initial step in providing the required legal framework for personal data handling in the country. So a quick overview of the Act. I mean, so if you see, of course, this is a busy slide, with a number of things. But first thing is, if you see on the left side, an applicability, right? So applicability is anything which is digital personal data. That is the scope. But also, non-digital data, which will be subsequently digitized, is also in scope. So that is the one thing which is in scope. The other thing is from a territorial perspective, of course, digital personal data in India is there, but also any data processing outside India, if it pertains to providing goods and services to data principals within India, is in scope. So there is an extra territorial scope, of the Act 2. Now, from a non-applicability, perspective, of course, there are a few things, if it is, if the data is made voluntarily to the public, or it is for processing, for personal or domestic use, or if it is, if there is any obligation under the Indian law, then it is there is a non-applicability there. The privacy principles of the Act pretty much are in line, with other key data protection regulations across the world, about lawfulness, fairness, transparency, purpose limitation, right? So you have a purpose, for processing the information, you should limit it to that data minimization, accuracy, and then there are also rights, which is provided under this Act to data principals. I will talk about all these stakeholders in a subsequent slide, but the key stakeholders would be data fiduciaries, processors, principals, and then of course here the data protection officer, if it is in scope, and then you have a data protection board and an appellate tribunal. So we will discuss all these things in a subsequent slide. There are also, as I indicated, rights assigned to data principals, for example, the right to access information for any kind of rectification or erasure of information. What is a little unique, of course, in the DPDP is there is also this right to nominate, which is not, I have not seen that in many of the other regulations across the globe. So this is, and I will actually cover some of the differences between this Act versus say the most popular GDPR, which is there. So we will just look at some of the similarities and differences there. Once again, as I mentioned, there is provision for a data protection board, and the board has not been yet, it's not in place yet, but then there is a provision including the structure of this board, which has been called out in the Act. So quickly moving on to the key tenets of the DPDP. So here are some of the key stakeholders and the terminology. So once again, as I indicated earlier, this includes both, from when we say digital personal data, it is both digital data as well as any data which was earlier not digitized, but later and subsequently was digitized, is in scope. Data fiduciaries, the law says it's any person, right? But here, any person, as the definition of a person is included in the Act, it could be a body of individuals, a firm, a company, and or an individual itself. So that's basically a data fiduciary, and the data fiduciary is the entity which determines the purpose and means of processing of the personal data. This is very similar to the concept of a data controller in GDPR. There is also a category of data fiduciaries in this Act called significant data fiduciaries, and these class of data fiduciaries would be determined based on certain factors. I mean, the factors yet have not been determined, but there have been references to possibly some of the factors which could deem a particular fiduciary to be a significant data fiduciary. And those could be something related maybe to the volume of processing, the harm that the processing could cause to the individual, violation of rights of the individuals, or to the safety of the nation, etc. So there are a number of factors called out in the law which can cause a particular data fiduciary to be called out as a significant data fiduciaries by the central government. But more on this to come as the act gets further flushed out. A data processor is anybody who is processing data on behalf of the fiduciary. From a data subject perspective, there are data principles, and also there is the act has called out about processing of children's data, and the definition of a child is any individual below the age of 18. And there is also what is unique in our DPDP is also this concept of a consent manager, which is an individual registered with the data protection board, who will act on behalf of the data principal, giving and withdrawing consent as required. We also spoke about the data protection board itself, which is going to be hopefully going to be formed pretty soon. And the data protection board itself has got a lot of powers, etc., and some responsibilities regarding management of complaints as well as enforcement of penalties. And of course, there is an appellate tribunal wherein if anybody is wanting to contest any decisions by the data protection board, this is the tribunal to which you can make your case. And this is the TSAT. Which is there. We will discuss about this also a little later. Main important considerations is, again, even outside India, it is applicable as long as if it is offering goods and services to data principals located in India. So even if the processing is happening outside, then there is applicability which is there. The data fiduciary, what's one very important thing is there is something called and which is very similar to GDPR also. There is a legal basis for processing, right? So one of the legal basis for processing is consent, right? So but then there could be other legal basis also for processing. So that has been called out in the law. In the event that consent is the legal basis for processing, it is important that a notice is given, a very clear, concise notice is given, which is easily evident to the users. And in the notice itself, of course, there are certain requirements as to what should be there in the notice. It could be what is the personal data being collected, what is the purpose of it, how what are the rights of the individual, how they can notify the data protection board, etc. These all need to be there in the notice itself, and then the individual provides the consent. So these are cases where consent is the legal basis for processing. The law also provides that there could be other legitimate uses which is not where consent is not required, and there are certain scenarios where somebody is willing to is sharing the data willingly, or it is to meet legal obligations or for medical emergencies, public welfare, etc. And also very importantly, which is there for corporate world, is for employment contracts. Again, the law calls out that it is not necessarily that you need to have consent. Okay, so that is basically one of the classes of legitimate use. The other thing, of course, is of course data principals. The data principals, they have rights, of course, to access and to seek rectification and erasure, of this of their information. One thing which right now the Act does not call out with respect to the rights of the individual is the right to portability. This is there, in a few other regulations, in particular, in GDPR. But right now, the Act is silent, on this particular right of portability. But who knows? At some point of time, it may also come in. But right now, it is not there. And of course, there is also the data fiduciary or a consent manager who can give consent. The other thing about this Act is also regarding data processes. There are not specific obligations called out for data processors. So all that is required to process data is just a valid contract. and it doesn't call out any obligations for the data processor, which is again a little different from what it is there from in other regulations, for example the GDPR. Data transfers, I think the main thing here in the act is that you should not be transferring data to restricted countries, which will be notified by the central government through a formal notification. So that is regarding any transfers outside the country itself. Of course, there are a few exemptions in the act, which is called out in section 17(1), which is again relating to if there is for example any kind of investigation which is going on for offense, etc. And also, for example, if it is a court-mandated merger, also is one of them, and any kind of payment default investigation, etc. So there are certain cases where processing would be allowed without requiring all the conditions specified for data fiduciaries. Okay, so these are in the exemptions category. Obligations and rights. First, I'll go through obligations of the data fiduciary itself. So if consent, as I said, right, your legal basis of processing could be either consent or some of the other legitimate use cases that we discussed earlier. Now, if consent is that legal basis for processing, in that case, it has to be in conjunction with a privacy notice, right? So that's one of the obligations. Again, cross-border transfer, it should not be to blacklisted countries. If you're going to do processing through a data processor, you need to have a valid contract. And again, securing personal data is an obligation for the fiduciary. Similarly, if there is any kind of data subject request known as DSRs, any kind of data subject requests which come in to the data fiduciary, the data fiduciary will have to handle. And one of the key things being a request say for erasure. So you should be able to service that particular request. And similarly, for any kind of data breach, there is a requirement both to notify the data principal as well as the data protection board. Now, from a practical purposes, in an organization, when we implement it, it would be useful to have certain automation and certain tools through which you should be able to do some of these. For example, consent management, if it can be done through a tool. Similarly, any kind of data discovery or any kind of a record of processing activities, right? So for all the different business processes, what are the different business processes, where personal data is collected, what you're doing with the data, what are the flows. If you're transferring data outside the country, are you sending it to a particular data processor? All these things, it is important, if there are tools, to do this, it will all be central in one place. It also helps, to evidence that, you have done the due diligence. What also helps is if you have it done through a tool, you can very easily do a gap assessment, find out what are your risks, then come up with a risk treatment plan. So that is why it's very important, rather than trying to do these things manually. If for some of these, if there are tools, that will be extremely beneficial. And there will be other cases also, for example, for DSRs, right? Data subject rights. There also tools could be very handy. So just a small pointer is that there are many tools available in the market, and many of the large vendors in this space, in this particular space, they've got multiple modules, and you can pick and choose which modules would be most valuable for you to use. And again, maybe during the Q&A, I don't want to actually name any particular tools in this webinar, but there are many of them, and then there are modules for these different vendor tools. So these are the obligations of the data fiduciary itself. From a data principle, we kind of broadly touched upon it. It is their right to access the information, and right for correction, erasure, and also for grievance redressal. There has to be a mechanism provided by the data fiduciary for grievance redressal. And similarly which is unique to our DPDP is this right to nominate somebody on behalf of the data principal. A quick deep dive into consent. Of course, we spoke about tools for consent management. What is important is this consent should be free, specific, informed, and unconditional and unambiguous. Right. So this is very important so that there is full clarity for the data principal at the time he provides consent. If consent is going to be the legal basis of processing, the notice should have a very, very clear language, that it's an informed decision made, by the data principal. The data principal has the right to withdraw consent, at any point of time. However, it means that if any consequence, of this withdrawal, of course, the principal has to bear. But more importantly, prior, to this consent withdrawal, any other processing which is done is not in scope, right? So only after the consent withdrawal, then you may consent that you may revoke your consent for data processing, but anything done before that is still valid at the time because you had given consent. And then of course there is a consent manager. This concept has been introduced in the Act, who is actually registered with the board itself, right? So with the Data Protection Board. So that is a new concept. There's a concept in this particular Act, which of course, if I compare it, with say GDPR, we do not have any concept of a consent manager there. Coming back, to this privacy notice, which goes hand in hand with the consent. Basically, the notice should indicate what is the personal data, what is its purpose, and then the way in which the data principal may exercise their rights. Right? For example, if you have to send an email to a particular mailbox, right? So you should mention that, in the data privacy notice itself, and also a way in which they can make a complaint to the board. Now this last point, the way to make a complaint to the board, it is because the board has not yet been created, so the contact address of the board is not there. So there is more, there is still some way to go for the Act. So once that is there, then at that time you should include that also in the notice. And one very important thing is, of course, because it's a multilingual country, the privacy notice needs to be either in English or one of the 22 languages as per the 8th schedule of the Constitution. This concept of a significant data fiduciary, we briefly touched upon it. This would be these factors indicated here would be the ones which could determine if you are a significant data fiduciary. Basically the volume and sensitivity of their data, the risks to the data principal, right, either to their rights or the harm it could cause to them, or any of these other risks which is called out here. If it is there, the central government may deem you to be a significant data fiduciary. So what happens if you are deemed to be a significant data fiduciary? The Act says that if you are a significant data fiduciary, you are subject to certain additional obligations. And those obligations are these. Think about it. There are three broad obligations that you have. One is that you have to appoint a data protection officer, India-based, and a senior person, right? Somebody who's reporting to a board or a seminal body. And that is one thing, to have a data protection officer. The second thing is you need to have an independent data auditor who will be conducting audits and against compliance to this Act. And lastly, also conduct periodic DPIAs, right? The data protection impact assessments need to be conducted on a periodic basis with respect to how you're processing and how what kind of harm could it cause. And this periodicity is very important because things could change during processing. So if you are a significant data fiduciary, periodic DPAs become a mandatory. So think about it this way. These three are the additional obligations for a significant data fiduciary. Okay, children's personal data, very similar also, to if you compare it with GDPR, it is there. So in this case, or for person with a disability, there would be a lawful guardian or a parent from whom the consent needs to be taken, and you have to be able to verify, that you have taken consent. Who is considered to be a child? Anybody below the age of 18 as per the Act. There are certain restrictions in the Act regarding what you can do with respect to children's data, and some of the restrictions are that one, you cannot. A process which can cause a detrimental effect on the well-being of the child. That's one thing. And any kind of targeted advertising or tracking or behavior monitoring of children is a no-no as per this Act. And lastly, of course, there are certain exemptions. If you are as a data fiduciary found to be safeguarding this data of children, then there are certain exemptions by which these restrictions you have will no longer be applicable. So that is also called out in the Act. So coming to this data protection board, which has not yet been set up and which is very soon a notification may come. And then, of course, it will take maybe a few more months for the actual board to be set up. This board, there is the structure of this board, with the chairperson and members, etc., is very called out in detail in the Act itself. So this is an independent body which is there, and main purpose is that they will be fielding any kind of complaints which data principals have regarding any kind of a breach of their personal data, or any kind of violation of their rights. And their role also is enforcement, basically on including handing off of penalties. One very interesting thing which has been called out is basically this particular board is there is a ask that it should be digital by design, so that it is not a lot of paper. So the expectation is that this board, the way it functions, it will function as a digital office, right? With having digital mechanisms for intake of complaints, as well as for performing the enforcement. So this is a very welcome pointer which is there in the Act itself, that it is digital by design, and that is what the expectation is from this board. Okay, so once this board is there, but if, for example, any order of this particular board, if there is any grievance against that, so you can again submit an appeal to the appellate tribunal. Of course, Khushbu, who's following me, will cover a lot of these as a lawyer in a lot more detail, but this appellate tribunal is the TDSAT, which is the Telecom Dispute Settlement Appellate Tribunal, right? So there is also provision that there could be alternate dispute resolution mechanisms. For example, the board may decide that there could be mutual mediation between the two parties. That is also an option that the board could recommend to the parties as a part of resolution. So that is the alternate dispute resolution mechanisms. Quick touch point on, let me see if how I'm doing on time. I think I'm just going to wrap it up quickly. The key similarities and differences with GDPR is of course the extraterritorial effect, this privacy principles, children data management, data subject rights, and grievance redressal mechanism. These are the similarities. The differences, as I told you earlier, there are no obligations for the data processor in this particular Act. This Act provides the right to nominate, of course, I also indicated, that there is no right to portability, it's not being called out, in the Act as such. There is a mention about the significant data fiduciary. And of course, there is a consent manager concept, which is not there in the GDPR. And also there is no distinction for sensitive personal information, in the Act, which is in GDPR, there is a distinction between personal information and sensitive personal information, which is special categories, of personal information. Okay, a quick thing, of course, I think Khushbu will cover this, in a lot more detail, but there are, various the provisions against non-compliance. So there are very categories like, lack of notification and actual breach itself, if it's related to children or it's related to a significant data fiduciaries. But basically the fines go all the way up to 250 crores. That's what the provisions against non-compliance. Let me just quickly summarize so this entire act is actually broken up into a number of chapters, and I'm just quickly wrapping this up providing a quick synopsis of what the various chapters are and the key themes in these chapters. There is obligations of data fiduciaries we covered. There are rights of data principals. There are these special provisions, right? For example, these countries where you cannot transfer data, as well as the exemptions. They all come under the special provisions. There is this data protection board which has not yet been set up, and of course there are these powers to the data protection board which has been called out. This is where I'm calling this digital by design approach with respect to the functioning of the board, which is the expectation as to how the board will function. We spoke about this appellate tribunal for in case you want to appeal against an order by the data protection board. Penalties also we covered. So that's pretty much it. So these are all this is what the entire act is broken up into these various chapters, and that's pretty much what I have. I'm just thank you for your time, and I'm going to hand it back to Giri and Khushbu to carry on with the session.
Thank you, Mr. Subramaniam. That was a very concise overview of the DPDP Act and its implications. I'm sure all the delegates attending this session will find them very instructive. So thank you so much for doing that. I know you were a bit rushed for time, but it was a very concise overview of the Act. I'd like to also request all attendees who are attending this session to post any questions for Mr. Subramaniam in the Q&A box. We will take up your questions towards the end of the webinar. And with that, I would like to go over to our next speaker, who's going to be speaking about navigating the data privacy law. It's important now for all cybersecurity and data protection professionals to understand the letter of the law and its implications and interactions with other laws and regulations. To shed more light on the subject, we have with us an eminent legal professional, Ms. Khushbu Jain, who's the founder and managing partner of Ark Legal. Ms. Jain is a practicing advocate before the Supreme Court of India and is actively involved in litigating financial crime involving technologies and cybersecurity issues. She's also been providing advice on technology-related legal matters, including data privacy compliance, to numerous corporate clients. So Ms. Jain speaks and writes extensively on issues relating to technology law, privacy, and cybersecurity. And she's an opinion column writer for newspapers and also a frequent commentator on national and international television. So today she will focus her talk on compliance and strategies for achieving and maintaining compliance. So over to you, Khushbu.
Thank you so much. It was indeed enlightening listening Mr. Venkatesh giving the entire overview of the DPDP Act, in-depth analysis about it, and thank you so much for organizing this and inviting me to address approximately 170 participants over here. Now today, as rightly pointed out, I'm going to navigate through the privacy law. So let's have a little bit of a background to talk on. I've got 25 minutes with me starting now, so till 4 o'clock. So let's go to the little bit of history of how privacy is all about, how it exists, how it came into existence, and then we'll go flow, and I'm open to questions. Okay, so 20 years back, I mean, none of us would have thought of something called as privacy, or, something called as getting a privacy in the digital space. Physical space, we did talk about privacy. We never allowed, people to enter into our house, into our, private places like privately owned offices or cars or, any of the property, your land. And there were laws in that regard, which was, where if somebody does that, you have something called as trespassing. You can sue them. But digitally, we never spoke something about that because there was nothing like that which, existed. But with the evolving technology and the way technology has revolutionized our entire world, that we are dependent on the technology. You pick up any sector, right from recreation, to health, to automobile, to the way we do business. I mean, I understand ease of doing business, ease of doing banking, ease of recreation. Everything has come up with that, and the way world has now become borderless with with the advent of internet, is where we have realized that, okay, digital privacy also becomes very important. Why it becomes important? Because all these data, all these instruments that we're talking about, or technology we are talking about, is in a way connected with data. And data plays a very crucial role for this technology, which till that time was absolutely fine. But with this boon, realize the bane, that apart from the uses of the data which is coming from this technology, there has been misuse as well. Misuse at 3 different levels. First level is when it comes to national security. More the data, easy for anybody to have any kind of crime committed, sitting at in their room, and just with a click away, do not have to come to the borders. We have seen that in the Russia, how cyber warfare has played hybrid warfare has played a very crucial role over there. I mean, one example, more the data, easy for them to have espionage done and have critical official data being transferred to in the hands of anti-state agencies. The second that comes is the aspect where, for the economy or for the companies, more the data with one company, easier for them to have businesses and, edge over the other one, which created a disparity. Without even having a legitimate competition, it created a place where, you can practically kill the business, or mom and, pop shop were the one who were at the expense. And how we have seen that it plays a very important role. The third that comes in here is, with obviously misinformation, disinformation again spreading, by the use of both states and non-state actor, and also when it comes to corporates, or, when it comes to entities. Then the third that comes is you and me. With you and me, we realize that apart from financial laws that are happening, more the data with these platforms, with the criminals, in the hands of the criminals, easy for them to orchestrate any kind of modus operandi, and orchestrate that crime and make you gullible to it, or make you succumb to that crime. Example, all of you must have had the dinner conversation that somebody has been fooled with KYC. Yesterday, the newspaper had, I think, 5 articles with respect to, including one of the actors who has lost money, approximately 1 lakh with KYC. There have been businesses who have lost the money because of duping people, and everything depends on the trust. And the trust is trust with the fear and fear and lure, and this lure and fear is added with the trust. Till the time you don't have the trust, you don't succumb to it. But that trust comes only when they have more data about you, easy for them to make you trust them. And once you trust them, that's where you become gullible, and that's where they commit their crime. Now, this increased a lot, and pandemic saw a lot, but before pandemic also, and countries across globe realized that something has to be done in this regard. Our data is playing a very crucial role when it comes to development, when it comes to evolvement, but at the same time, it is playing a very crucial role when it comes to crime. And that's where they realized that there has to be some level of sanity. Now, India also realized, a matter was filed in Supreme Court, 𝗧𝗵𝗧𝗀 versus Union of India, where courts went through rigorous discussions and rigorous submissions by parties, numerous parties, where they went and they realized that one cannot have a dignified life, without having privacy in place, digital privacy in place, because now everything, practically your half-life is, in the digital space, in the realm of digital space. And if you don't have that digital privacy, dignified life cannot be there. Hence, Article 21 of Constitution of India said, which is your right to life, the right to privacy is now part and parcel of that. That's the first time that India gave a recognition to something called as right to privacy. And that's now part and parcel of your Article 21 of Constitution of India. Though it became your fundamental right, but the problem that came is, how do you exercise that right? When I say how do you exercise that right, like, for example, you as a corporate, it is impossible to work without data today. You have to have data in place. What if tomorrow everybody says, I have right to privacy? You can't. Practically, businesses cannot run. Technology cannot run. There is some level of data somewhere. Let's say I enter to your premises and in your building, and I say that, no, you can't take my details. I want to enter freely. You say you have to. I can give you 20,000 examples when it comes to importance of data. And I think you will be more equipped with industry you people are into to understand how important the data is. I'm not getting into what level of data, but any kind of personal data. But with that, and for users like for citizens like you and me, for us to understand that where can you exercise that right and how do you exercise that right. Now, this was the point of contention, and that's where in the same judgment, which is 𝗧𝗵𝗲 versus Union of India in 2017, they said, let's formulate a committee which will understand and which will bring in the framework which will talk about what are the obligations or, what are the rights and how these rights can be exercised by data principals, that is users, that is you and me, like citizens, and what are the obligations or what are the contours under which the enterprises, that is data fiduciaries, have to work with. Now, the Justice Shri Krishna committee went little ahead. Instead of giving just a framework, they went on giving the entire draft bill. That's where 2019 bill came into existence. They presented the same. It was presented in one of the parliament session. From then in 2019, that is your Personal Data Protection Act, bill of 2019 to 2022, November 2022, 100 plus amendments went through that bill. And we realized that the whole essence of the bill has the whole bill has lost its essence because of so many amendments. The ideal way to do it is maybe recall it. That's why they recalled the bill. They bought a new bill, which is Digital Data Protection Bill of 2022 in November 2022, asked for the recommendations with every stakeholder involved and public. And in the last session is where the Digital Data Protection Bill became an act, and that's now DPDP Act 2023. That's where we are standing today, and now we are understanding what exactly DPDP Act is when it comes to organizations. And I understand the entire audience here is from the background of IT or security, and that's where the audience is. So that's where how one has to understand what exactly this DPDP Act entails, and what are the legal obligations, and what are the penalties imposed, and how do we navigate through this entire act. Now, to give you a little bit overview of the act practically, unlike anything else, doesn't talk anything to do with security. It doesn't say what level of security you have to keep in place. It doesn't talk about what exactly are the security measures one has to keep in place. It's practically talking about, it's pro-users, it's pro-citizen. So it's practically telling that me as a user or as a citizen, as a data principal, what are the rights I have? And in lieu of that rights, what are the obligations that data fiduciary, that is companies, have to comply with? And even in the event of, infringement of those rights of data principal, what are, the obligations in the absence of performance of those obligations by the data fiduciaries, what are the penalties that can be imposed? Apart from this compliance part, the next that comes is in the event of breach, because all of us say that attacks are here to stay, it won't go away. So in the event of the breach, what kind of penalties can be imposed on these data fiduciaries? They are not, again, I'm saying the bill is pretty simple. It's hardly section 40 sections. Very simple English. The whole intent was for making it understand to a layman. Every citizen can understand. You don't need a lawyer to navigate through the act. That was the whole purpose of it. So all they're talking about is rights of users, obligations of data fiduciary, and in the event of breach, what are the penalties that can be imposed? Now, unlike anything else, that do they talk about any standards? These are the basic questions. No, the act doesn't talk about any standards to be prescribed, to be followed by anybody, but they talk about reasonable security standards that have to be maintained. And in case the breach happens, then the penalty would be imposed. So now how do you navigate through this entire thing, and how do you make sure that you don't first get into penalty imposed in case of non-compliance, and in case of breach, how can you make sure that minimum of the penalty is imposed on you, or you escape the penalty aspect of it? That's where I think the whole understanding, we can go ahead. Now, to understand what exactly are the rights of the data principles, Venkatesh ji has already gone through those things, but I'll still take the liberty of taking you a little bit of, in the aspect of what exactly are the rights. First, let's understand what is the applicability. Is it applicable to you or not? That's the first thing in any of the act one has to understand. So one has to understand this has to do with anything which is a digital data, anything which is a physical form of data, which is not digitized. This act is not applicable on you. That's the first thing. Now, when I say physical data, like for example, if you have a physical form and you have details in that and that is kept, you're not. But the moment that data, either it is digitized, that has been filled up online or in a digital form, or a picture is being taken via some electronic instrument, including WhatsApp, including phone or a scanner, and it has been shared even by a WhatsApp or any of the mode, which is electronic mode, that's where it becomes digital, and this act will be attracted towards that part. So that's the first applicability aspect. The second applicability aspect is, does it apply to overseas? And yes, it does apply to personal data that is processed outside India as well. Let's make it very clear. But only if such processing is done, which is in connection with activity which is related to offering services or goods to data principals in India. That is data subjects in India. So that's another one thing. If this comes, this is the scope or applicability of the act, and you can attract the DPDP Act, or you come under the purview of DPDP Act. The third exclusion that very clearly is been put in over there is that in case the data has been processed by an individual for a personal or a domestic purpose, then is where this act is not applicable, or you cannot attract the clauses of this act. Or if this data or a personal data is publicly available by data principal herself or himself, or under any other legal obligation. So that's, again, you cannot attract provisions of this act in these two scenarios. So that's the first thing one has to understand, whether this act is applicable to you or not, and in what manner can you, whether there are any instances where you can attract. Now, the second that comes is, after we understand we are in the purview of the act, now the act talks about, as I said, it talks about no security, but it's practically pro data subjects or users. And that's where it talks about that practically it talks about essential principles, the principles which we were reading from long back, the 9 privacy principles. It practically in a nutshell talks about those principles. But if I have to talk about protecting data principles, that is, what is the collection limitation and what is the purpose limitation. So that purpose limitation has to be defined, has to be there. Like, for example, our personal data should be processed only for a lawful purpose for which the data principal has given its consent, and that also in accordance with the act. Now, when I say in accordance with the act, that's where we'll understand that how that consent has to be taken and how that consent has to be maintained and what are the rights applicable over there. And if I have to go more in detail of the consent aspect, let's understand, because this will be the basic compliance you have to look into. And in the absence of this consent being in the format or in the manner which is being prescribed in the act, in the absence of having that in place, you don't have to wait for the breach to happen. You don't have to wait for the attack to happen. You practically, just by non-compliance of these basic requirements, you attract penalties of 50 crores, with each breach, each non-compliance of these things. So when you talk about consent and a notice, the first and foremost that comes is affirmative consent. And when I say affirmative consent, that it means that it just can't be random the way we have seen till now, how the consent has been taken, and it's in disguise. Practically, it's impossible even for lawyers to understand what is there and not there, and you practically say yes to it. No, it has to be one, it has to be free, it has to be specific, it has to be informed, and it has to be unconditional and unambiguous. These are the 5 words which you have to keep in place: free, specific, informed, unconditional, and unambiguous. It has to be in a very clear affirmative process. It has to be maintained, and it has to signify very clearly that a data principal is in agreement for processing his or her data for that specific purpose. Now, when I say that, it has to be very clearly that, informing that what is the purpose of processing. Like, for example, you tell in the notice that what data are you, what exactly is the data you're taking? One. Second, what is, along with the information with regard to what is the proposed purpose of that processing of that data. Then comes is the manner in which one can exercise their consent. Also, is there an option of recalling it? Is there an option of erasure? Is there an option of correction? Is there an option of grievance redressal? All these things have to be part of the notice. In the absence of any one of that, also attracts the penalty, and you will be put to the board to give a response to it. The other thing that comes is if in somebody withdraws the consent, do you have an option to provide? So first, free and clear. And when you could talk about clear, there is one more aspect that is there, which I think Venkatesh ji also covered, that it has to be in 22 languages, which is part of 8th schedule of the Indian Constitution. The 8 languages which are mentioned over, 22 languages which are mentioned over there, and you have to put that in those 22 languages. It cannot be just auto translate. You have to look into it and have a very precise, clear, notice or a consent which has to be drafted. Now, when you talk about withdrawal, you need to have one which is an option of withdrawal. The second, that option comes as erasure and grievance redressal. Now, when you provide, these are the options which should be very clearly available via website itself, via digital mode itself, where I can seek, one, what my data is available with you, what exactly is the data that you are asking for or you are processing. Do you have an option to provide today? Maybe in your organization, you have to go back and learn and understand that what exactly are the data that you're taking. Are you having that entire chain of information with you right from start to an end point? Now, when you have that, how many third parties are in process? Who are the third parties you're sharing your data with? Now is the time where you have to tell them that which are the third party which are going to utilize the data. In case there is an addition or subtraction to that third party, you might have to again notify them with a pop-up and making them understand and making them agree to it, that these are the more parties which are going to process the data. You cannot just have third parties and a group of companies. You need to provide clarity to it. Thumb rule. The Act talks about accountability and transparency. When I say transparency, this is the transparency that we're talking about. You can't have an ambiguous way of taking consent and processing the data of subjects. It allows you to process the data. It doesn't take away your right to process the data and have your business run over the data. But at the same time, it's bringing in certain obligations, which were the ethical and moral obligations one should have followed till now. But in the absence of the way things have been transpired and things have evolved, there was a requirement of a legal requirement into it so that some punishments can be imposed on them. When I say multiple languages, you can look into the 8th schedule of the Constitution. For the paucity of the time, I can still read it. That is Urdu, Tamil, Telugu, Sanskrit, Punjabi, Marathi, Hindi, Kannada, Bengali, and Gujarati, Kashmiri, and so on and so forth. Now, when I say legitimate, the next part that comes with you is the legitimate use. When you say that, can I process the data without even taking the consent? Is there an option of processing the data without consent? Yes, it has in a way talked about deemed consent, though it has not worded the deemed consent, but it has made it in its own way, which is which was there in the earlier bill. But it has now, in a way, rechristened the concept of deemed consent, and it has come to a level where, let's say, there is an aspect of responding to the medical emergencies for the purpose of employment, for performing functions under the law, or the state providing any services or benefit to the data principle, or for compliance of any judgment or any order issued under any law, so on and so forth. These are the exceptions which have been given, and in these scenarios, there are deemed consent. You did not go for a explicit consent or a the way consent or notice that we were talking about. These are the exceptions that are there when it comes to legitimate uses, where exceptions can be there. Now, these are the rights. The other right which are basically there, which I already put in part of. One is the knowledge. The second is having knowledge of what exactly are the other data which has been processed. The second is correction. The right to correct. The third that comes is erasure till that time which is not there, and right to be forgotten has to be completely part of right to privacy, because if you don't have something called as right to be forgotten, you can't have something called as right to privacy in place. So right to erasure has also been part and parcel of this new act, and one can exercise, provided there are manners in which you can exercise that right, until and unless that data is being utilized for the purpose for which you have given a consent and for the services that you're still taking. in that scenario, you can't. But in the scenario that purpose has gone away with, you can recall, you can ask for a complete erasure, provided, again, if they are not barred under any law or there is no other legal requirement which makes them mandatory to keep the record. Like, for example, telecom data, like, your data has to be maintained under the law. So even if you have stopped using the services of one of the telco and you say that I want a complete erasure of the data, the law bars them to do so for the next 2 years. So that's where you can't exercise that right. But for companies like yours, all of you have to have that in place, that what exactly are the legal requirements in place, so that you can give a response in the manner which has been required. Because in case one exhausts that remedy and the proper response doesn't come, that's where that user, after the grievance redressal mechanism being availed properly, can go and appeal in the board, and you'll be attracted to to be called in the board. So I think that's where you have to come in place and understand what data you keep, how it is directly linked to the services. One, second, if it is not, then whether they can under the law ask for complete deletion. If not, then this is the reply that has to go. And if both of things do not come up, then is where they can exercise that right, and that's where you have to act upon. You cannot sit silent. So again, 50 crores of penalty comes in place. Apart from right to erasure, there's another thing that has right to nominate, which till now was not there. But as all of us have been reading, and this has been a very catchy oil, data is the new oil, data is the new asset. Yes, data is the new oil, data is the new asset. Data plays a very important role. So you can now nominate. Now, how can you nominate? In the event of death, in the event of unsoundness of mind, in the event of incapacity. These are the areas where you can nominate somebody else, that for my data, this is the person who's nominated. Now, when you nominate, they can even exercise the right to delete. It's been said that by 2030, there would be more dead people online, dead people's profile online, than the alive people. So that's where I think they can exercise their right of, and data also is very important. There are NFTs in place. There are a lot of other things in place where they can have monetary benefit into it, and they can transfer that right to somebody else. I think I have another 7 minutes left, so I'll go a little more fast. Apart from this, again, grievance redressal is another right which data principals have it. These are the rights. Now comes this data obligations of data fiduciary. Now, when I talk about obligations, there are certain compliance which DPDP, under the DPDP Act, which has to be taken care by data fiduciaries. That involves the aspect of notifications of any kind of personal breach that has been, that has happened. So they need to be intimated. They need to intimate this to the board, that and also each affected data principal in a manner that will come up as a form that will be prescribed by them. So you have to make sure that you inform the board, you inform the affected party whose data has been breached. Again, as I said, the law is for the users. That's where the whole thing comes up. Nobody can now cheat you. Let's say tomorrow your password, your phone number, your other things have been breached. And that's where you have already been informed that from so and so date, this has been breached, please look into it. Now, let's say some phishing call comes to you and they call you up and they tell you that I'm calling and I have this detail. So you'll be aware that this has already been breached. That's how the person might have an information. I should not fall prey to that. So that's how, the exercise has been done. Then there are certain extra obligations when it comes to significant data fiduciaries who can be SDF. Again, SDF can be dependent on the volume of, it's yet not been there, but what understanding that comes from the Act is the volume and sensitivity of the data, personal data which has been processed, the risk of the rights of the data principal, and the security of the state, and so on and so forth. So these can be criteria by which you can be determined whether you are significant data fiduciary or not. And if you are, then there are certain extra level of obligations one has to keep in place. I'm not going with the paucity of time. I think Sir has already covered that part. The most important, all these things the most important that comes is processing of data of children and person with disability. Don't forget the aspect of person with disability. There has to be a verifiable consent of a parent or a lawful guardian, which is required to process data of children and person with disabilities. Now, person with disabilities is where you have to play a very important role, and you have to understand how things have been, how one has to do that, and what consent mechanisms you have to have in place, so that you make sure that there is a verifiable consent of the guardian or of a parent, a lawful guardian or a parent. It also, in a way, prohibits tracking or behavioral monitoring or targeted advertising directed at children, or any that, which can lead to a detrimental effect on children, well-being of a children, or of a person with disability. That's where I think one has to play a very important, crucial role to understand that aspect. Another thing that comes is any other compliance requirement. If there is a breach, there is a penalty which is 50, or in one or two scenario 100 crores. But this is where the penalty may go up to 200 crores. So this is something which you really have to look into, with a great focus. Now, formation of the DPDP, the Data Protection Board, has already been discussed by Venkatesh sir, and I'll also talk about it is yet to come. I think a week back there was a statement by Minister of State, IT, where he has very clearly mentioned that we are ready with the board, and within a month something will come up with the board. The formation of the board has already been discussed, and in the latest with him there is a process of appeal. Once you have exhausted your remedy as a grievance redressal from the data processor, one can go and appeal in the board. And board, there is another thing which has to be kept in mind, that it cannot be just the affected party like data principals, but also suo motu the board can take action against you, or can start working on it. So one has to be very vigilant on that aspect as well, to take it more seriously. If you're not happy, there is a process to appeal, that is TDSAT. And then after that, TDSAT, you may go to the Supreme Court and appeal. It's the same level, same way that has been done. Now, penalty part of it, I really I have another 5 minutes. Let me okay, there are some exemptions to the and this is the question which has been asked a lot. So certain startups are being exempted. Now, when I say startups are exempted, the question that comes is, can I do one thing? Can I have a startup in place and let all the data be processed by the startup, and let me be the one who will not process, and I'll not attract this act or the penalties which have been there? No, you cannot. So startups, the whole idea behind giving an exemption to the startup was that we want innovation to happen, and the way AI is happening, AI and ML, and the way we want to strive, we are not even coming up with a regulation when it comes to AI, but we are coming up with basic understanding into it, and we are putting in a lot of money in AI and technology. That's where we want to make sure that the country doesn't go back, but it flourishes, and we have a lot of growth when it comes to our own India tech. When I say India tech, that's where they're saying that, okay, we are going to give exemptions to our startups, so that this act doesn't strangulate that industry, that budding industry, Indian inks. Now, when I say startups have been given exemptions, that doesn't mean a complete exemption. It says they will define the category or the type of startup that would be eligible for that exception. One. Second, it would be pre-business. So till the time, let's say you're building on some product or some services which has to be to be put in, take up any example in health, or any anything to do with whatever example you want to pick it up, you can continue to do so till pre-business. Once you come into the business is where that exemption goes away from you. So you can have as many data sets, and you can continue to build your product as much as possible. And once you have done with that, the moment you come in the business, that exemption goes away with you. That's one of the beauty of the act, that it's pro Indian inks and innovations. The other point which I had to, and I wanted to discuss in depth, is penalty part of it. There has to be a lot of use cases. We have to wait and watch how things will transpire when it comes to the way board will act, and how it will act, and what will happen, because it's always after a lot of precedents that one understands that what are the overviews of the act and how things would be. Because today also there are a lot of things which are contradictory, like for example, certain guidelines are still in place, and which obligates every company to practically inform within 6 hours of any breach to the certain, whether that will come in or whether you have an obligation just to the board. I think you have to wait for the notifications to come, the rules to come. Once the rule comes, I think we can have another discussion in place which will give you in-depth analysis. I'm taking another 2 minutes, please, and let me just talk about just basics as to what will be the criteria for determining penalties. I think this will give you a little more understanding as to how do you implement this act and how serious you should take this act or these compliance aspect to it. So when you talk about what board will actually look into, so there are certain factors which will determine how much penalty to be imposed. Because if you look into every penalty is up to 50 crores, up to 100, up to 250, up to 200 crores in categories which have been there. Now that up to how do you minimize it or how do you escape that will be determined on the aspect of, one, the nature and the gravity and the duration of the breach that has happened. These are the very important part where board will look into. The second that comes is the type and nature of personal data affected by the breach. So when you talk about type and data, let's say very severe, very crucial data has been gone away with, that will again determine what penalty can be imposed. So there would be a different criteria based on nature and gravity and duration of the breach, one, and the type and nature of the personal data that is affected by the breach. The third that comes is repetitiveness of the breach. That's where, when I was saying that the act doesn't talk about what security measures you should keep in place. It just talks about reasonable security standard. You're from, you're from health. Whether you want to look into NIST guidelines or HIPAA regulations, you're from automobile, what kind of guidelines you want to look into, you're open to it. Just the ISO 27001, absolutely okay. But in the event of breach, and if there is a repetitiveness of the breach, the penalties will be determined on that. Second repeat, third repeat, I think you can entail the highest penalty possible, because that shows how lenient you are when it comes to security of your users. And the fourth that comes in place is the realization of the gain and loss due to the breach. Let's say with that breach or with that thing, you have gained a lot of money or somebody has lost a lot of money. The users have lost a lot of money. So that quantum will also determine what quantum should be put on, imposed on you as a penalty. Then impact of the penalty on a person while determining this breach will be, what impact it has on the person who has been there. Like, for example, let's say my very sensitive data that has been gone out and it has made it very severe. Like, for example, health data which was being breached of breach candy had every detail possible as to what exactly are there. And there are a lot of diseases which you don't want things to be outside, in the purview of people or in the public. So it really depends on the impact, and that will also be a determining factor for quantifying the penalty imposed on you. I think we have to wait, one, for the rules to come, notifications to come in this regard as to how things will play, and also for another some more time for the board to continue to have some use cases to understand how board is gonna work on that part. But nonetheless, you need not wait for it to come, because the basic compliance which is being described above, you have to have that in place, and best to have it technology in place, because you cannot exercise that right of erasure or correction or things like that just by one request. You'll be flooded with the kind of requests or notices that will come to you. Best is to have that flowing from your technology itself, so that you have in place. Like, for example, let's say I exercise my right to erasure, and you are under obligation now to exercise, provide me that right, because you're not obligated either with the services or with the law. Whether you exercise that right or not, then I can sue you. So that's where you have to have things in place that on 11th October, approximately at 4 o'clock, Khushbu Jain, with that, whatever number you want to give me, has exercised and requested for deletion. So at least that call, that log is maintained with you in the diary. So tomorrow when the board requests you for anything or any question comes, you have that ready and handy and put it across. So maybe you need to have a proper compliance, being done from implementation part to bookkeeping part. Thank you so much.
Thank you, Ms. Jain, for the very sort of succinct exposition of the law and its multifarious implications in practice. So I think as we await the rules and regulations on personal data protection, I'm sure your advice will stand us in good stead and sort of help us plan some actions and even to communicate to other stakeholders within the organization. So thank you so much for this. I'm sure there's, many more implications that will come once the rules are notified. And, as you said, those use cases will come. So the board will decide how to deal with them. But I think there's a lot of anxiety, which I'm seeing, among the questions that are posed by some of the delegates. So, to take this forward a little bit more, we now have a very experienced and expert speaker who's already advising many corporates on cybersecurity and digital transformation, as well as privacy implication. I'm very pleased to introduce Mr. Jaspreet Singh, Partner Clients and Market Leader and Advisory Services, Grant Thornton. Mr. Singh has over 18 years of consulting experience. He's focused on cyber technology risk and enterprise risk and digital transformation. And he manages large and complex transformation programs, and he has advised many clients on digital strategy and transformation processes. He also runs the virtual CISO office for many of Grant Thornton's clients and is a trusted advisor on cybersecurity. Today, he will be covering the topic Roadmap to Compliance with the Digital Personal Data Protection Act. So over to Mr. Jaspreet Singh.
Hi, everybody. Good afternoon. Thanks for giving me this opportunity, Girdhar sir. It's always a pleasure, seeing you, speaking with you. It's a very, very difficult task that you've given me today. On two reasons, right? The first foremost, it's very difficult to follow such eminent speakers. Venkatesh sir is like a grandfather of the industry. From a technology perspective, Khushbu, you can't ever argue with lawyers. And then I've been given this task to help simplify what the roadmap to compliance would look like. So I thought, why don't we start with and I think Khushbu and Venkatesh sir alluded to some parts of it on how do we start, right? Where do we start from? What is the first step that I will take? It's an act, yes. 40 articles, yes. Rules not defined. But if I have to take a punt, where will I start from? There are a lot of organizations. We probably are doing 3 awareness sessions a day to board of an organization on what you should be starting from. If you look at it, this entire game is about data principles. That's why I think, like Khushbu rightly mentioned, that's how this act has come about. And if you look at what the data principles rights are, right, whether it's the 6 rights that we're talking about, how do you enable them from a technology perspective? I think we have got close to 153 technology leaders on this call. Can anybody put their hand on heart and say, today they understand where is the data flowing within their organization? And right now I am talking about structured data, right? What about unstructured data, which we all collect, download, put it on our website, put it on our laptops? How do we deal with that type of data? So my first advice or first comment would be that everybody should understand ingress and egress. How does data enter an organization? How does data exit from an organization? How do you do that? A very simple principle when we all started working was we created something called as a data flow diagram, right? Data flow diagram, input, process, output. Just imagine an HR function, imagine a finance function, wherein data is coming in, you are processing the data, storing the data. And when I say data, I am doing this for all types of data, aggregating what is PII in that data. Once I understand what is the PII, personal identifiable information, then I put reasonable assurances in place to safeguard that data. So the first step that we are talking about is doing a data and information life cycle management. Superb. I have done information life cycle management. I would then focus on updating my policy procedures to meet the requirements of the Act. Every organization today has a data protection policy, data privacy policy, whatever you might want to call it. How do I update my policy to reflect what are the key changes that have happened in the digital data protection bill? How do I make those changes is going to be a key piece. Then putting a implementation roadmap in place. To all our clients, we are saying that you should probably divide this into 3 pieces. The art of possible today. What is the low-hanging fruits that we need to implement today? Could be a gap assessment, could be data flow diagram, updating your policy procedures. To a medium-term goal. A medium-term goal looks like developing your data inventories, but also developing a long-term goal on having a holistic information lifecycle management in your organization. I'll give an example. Khushbu mentioned the right to deletion, the right to erasure, or the right to deletion of data. If today I send an email to CIO and leader saying, please delete my data that I participated in this webinar, Can somebody in CIO and leader stand up and say, boss, yes, we have deleted this data from our training records, this data from our HR records, this data from our sales records? How would you know where does data exist within different touch points in your organization? Only if you're able to command that will you be able to give people the option of exercising some of these rights, which become very, very important. And hence, looking at technology and security controls. Another very important piece from a technology perspective is the entire breach management procedure. They're saying in case of a breach, and Khushbu covered this, you need to inform the Data Protection Board of India. In how much time, who will inform? The rules are still being formed, so jury's out there on that. But it also talks about the responsibility of informing the data principal. So if I'm an employee of your organization and there is a data breach, you have a judiciary responsibility now of informing me also. How would you put in controls to make sure that you will inform Jaspreet? What will you inform about? Imagine it's a very small data breach. You inform Jaspreet, and somebody puts it on social media. It will be a total chaos out there, right? So, what are these type of controls that you will put in from a breach management perspective? Lastly, I would put enough technological controls in place. For example, if I'm in hospital and I can work with a unique patient ID, then I will stop using a lot of PII data in my internal communication. And that's again what the bill alludes to. It's called data minimization. Walk into an interview and you will see the HR makes you fill a 3-page form. Do you really need that 3-page form? And what is the purpose of the data that you are collecting? A lot of organizations will now go back to drawing boards, look at business practices and say, what is the data that I need? Do I really need this data? How much time do I have to store this data for? Again, as an example, if a data principal exercises a right to be forgotten, right, then will you delete all my data? The answer is no. There are different judicial reasons for which you need to keep some data. For example, as per I think it's the Income Tax Act or the Provident Fund rules, you need to keep that information for 7 years. But you need to go back to the data principal and say, hey, Jaspreet, I have your attendance records. I have your training records. I will delete those records, but I won't be able to delete the records on. I won't be able to delete the records on PF and income tax because we need it for judicial purposes. So that's again a very, very key area that companies need to look in for. So if I were to actually put and I think the slides have now come on. If you just go to the third slide, please. I don't need the slide, but since you're presenting, yeah, this slide. So if I were to actually look at what would organizations need to do from a journey perspective? Absolutely, first start with gap assessment, update your policy procedures, understand what's the data on ground, but equally exercise your data inventory. It's a huge, huge exercise. We work with almost, I would know, top 200 CIOs, CISOs in this country, and believe me, nobody can put his hand on heart and say, boss, I know every data that exists in my organization, whether through technology or through manual controls, and then put security controls in place. I would say this would probably be should be your next 60 to 90 day plan. Then from a 90-day plan to a 150-day plan, you should probably look at data principal rights. You should put the entire governance framework in place. What if you are a significant data fiduciary? My fellow speakers have spoken about that. You need to appoint a DPO. Who will be your DPO? Can a CISO be a DPO? You can definitely make a CISO a DPO, right? But will he understand the law of the land? Will he be able to represent you in a court of law should the need arise? Will he understand the legal language of how a consent is written? Right. So some of those pieces are jigsaw puzzle that you will need to start putting together. And the last is, how do you sustain it from a tools perspective? Look at tools around privacy enhancing technologies, look at automation tools, so on and so forth. Next slide, please. Thank you. This is how a lot of people in industry, and I'll talk about three key examples of the largest insurance GIC in India, the largest healthcare company, a hospital and a diagnostic center, and a telecom operator. We working with some of these clients to help them comply with the proposed whatever is publicly available of the app. Everybody's done the entire piece on gap assessment and identified a roadmap, like I just showed, saying this is what I need to do from a technology perspective. This is what I need to do from a process perspective. I need to enable my website to, like Khushbu said, give me options in 22 languages, right? It becomes a nightmare when you're dealing with 800, 900 customers a day. Imagine if you're an hotel and you have to give me a consent option in 22 languages, right? You'll probably go crazy giving me those options itself. Then developing your data privacy framework. Now, people come and ask me saying, how do I write my incident management procedure if I don't know whom do I report to and what needs to be reported and in how much time? See, if you look at the way this law has progressed, and if you pick up any other law in the globe, I have done a study of about 30 odd laws which talk about incident management. Some talk about informing XYZ, the board or the supervisory authority, as in case of GDPR, within 72 hours. Our certain says 6 hours, but you need to still have an incident management procedure. So until unless you have the capability to detect and respond to an incident, which will itself take some time setting up, all you need to do is draft this policy procedure, enable technology controls, and then tweak it to make sure that you can do this in 6 hours, 24 hours, or whatever comes of the law. So 60% of this entire act can be implemented now. The rest can actually be implemented once the rules come in and we have little more clarity. Similarly, from the security of processing perspective, you need to put in adequate security controls, which does not depend upon the rules that will come in. Next slide, please. What I did was I thought, let's try. So people ask me what kind of data should I look out for. What I did was we written down 5 departments and shown just from a department perspective how much data, PII data, do you actually capture. Correct. Working with one organization, and they actually identified about 37 different data types that they collect that could potentially, with the mix and match, become a PII, which is a huge cause of concern because then you need to put in controls to monitor, manage, and save that data and put in reasonable safeguards or reasonable assurances. The last piece, like I said, I've already covered this, but if you'd see, I would divide these initiatives into 2 pieces. Next slide, please. Between a process initiative and a technology initiative, it will have to go hand in hand. I still firmly believe that technology going forward, especially privacy enhancing techniques and technologies, including data classification, data discovery, incident management, some of these technologies going forward will play a very, very key role in making sure that not only you comply with this act in letter but in spirit also. Thank you. Back to you, Girdhar sir.
Thank you very much, Mr. Singh. I think that was a very short, but I think very, very informative presentation that you made. I think you have managed to answer a lot of questions that people were putting up in the chat during the interview about, what they should be doing, how they should be doing. And I think Mr. Subramaniam was also answering some of those queries. But I think you have managed to effectively answer a lot of those questions for people. I'm sure there are many more questions that people have, but I'd really like to thank you for summarizing this so succinctly and so usefully, particularly in terms of those charts. That's why we need more consultants. I think you've done a great job. So, let me just take up, quickly go through the questions. Perhaps there are a few that could be answered by the panel before we bring this session to a close. So I think Anil Porter has a question which says, I'd leave it to any of the panelists. Do you expect any surprises in the rules that the board will prescribe?
I don't know what surprises means, but yes, rules actually will form the backbone of the entire act. So nobody knows which way the rules will swing. If you look at some of the clarifications that were issued after GDPR came into picture, cricket fever is on, right? They were literally bouncers that hit. But I think the best answer would be, let's wait for the rules to come in.
So, Khushbu, this is a question perhaps you can answer. So, what department would be responsible in an organization for enforcing DPDP? So will it be HR? Will it be legal? Will it be IT? Who will be responsible?
So one, if you're a significant data fiduciary, you have to have a data protection officer in place who will be the responsible and will be responsible to the board as well. And he'll be the one who will be the responsible part when it comes to grievance and, when dealing with the data protection board. When I said responsible to the board, responsible to your own board in the organization and also responsible to the data protection board. When it comes to non-significant data fiduciaries, that's where I think you have to assign a role. But the way we have been seeing, the kind of obligations and rights which have been given, and those rights also have to be looked into as an obligations by the data fiduciaries. You need to have somebody dedicated who looks into the compliance aspect, somebody who's not into security, because I understand people have put in CISO and DPO as, one entity. Even if you put that, you need to have a separate team, two separate team altogether. One who deals with the security is not the one who can talk about compliance. They might work hand in hand, but you need to have a team of compliance properly in place, because it's not a job of somebody who's already been doing a humongous job of keeping security in place. If I'll give you in a nutshell, right from amending your contracts today, which are in line with DPDP, so that you transfer your liability, or you make sure that they are also in line with the Data Protection Act. Also from there, first point to end point, the whole journey of the information and what are the third parties involved into it. When I talk about erasure, it's not just your organization who has to erase, but if that data from you has gone to 50 places or is in your 50 departments, it has to erase all the places. So all the departments will be place of it. So somebody has to make sure that they look into that entire aspect and, work on it. There would be plethora, there would be literally floodgates when it comes to kind of queries that would come to you, what response has to go, what kind of format, and one has to reply to the board. In case there is a little bit of breach that has happened, how you have to inform, what you have to inform, because apart from the legal obligations under the act, you do have something called as reputation loss. You just can't randomly go and talk. So what level of information has to go out, in what manner, how much one has to, everything has to be looked upon, and there has to be a dedicated team one has to look into. You cannot go with the size of employees you have, but you have to understand the size of data that you deal with.
Thank you, Khushbu. I think,
and Giri, if I may just
please
add to that. See, it could be, because we are just starting now. So that's, and this will come, right? Is there a conflict, right? If the security guy is also the privacy guy, I'm sure it'll come. But right now, I think what is important is people implement, right? So the reason why this is just my take, and I'm sure there are many CISOs who ask this question, in the panel right now. Maybe because of the context, the security guy is in a good position to give this program a start, right? So I think that will be very important. But as the program matures, then then there would be the conflict of interest, the maker checker, right? Because if the security guy is himself doing the data discovery and data subject request and data protection, who is overseeing him, right? So that will come at a certain point of time. Absolutely, I do agree. But right now, if there is somebody who has to immediately start the program, in my opinion, the security guy would be in a good position to give the program a start, and at some point of time possibly hand it over, as Khushbu is saying, to a dedicated team of privacy office with privacy members. That would be the best way, rather than right now itself trying to build a structure of people who may not be skilled in a lot of stuff. And then there should be internal conflict within the organization that we should avoid. So that's just my thought, as to what would be the most prudent way to go about it.
Thank you, Venkatesh, for injecting a bunch of practical insight into this. I think Jaspreet had mentioned, in his roadmap that up to 60% of the stuff can be done now. So Jaspreet, do you recommend that the CISO and his team take charge at the moment? What are you advising?
CISO or a DPO or somebody from the legal team, there are conversations with the chief compliance officer have also started having. But Khushbu made a very valid point, right? It is not an initiative that one person can run, because if you ask me who's impacted by this, every single department of an organization. You will need to look at it the way you define your security governance structure. You've got representatives from each department, right? Whoever leads it, whether a CISO leads it for now, you would need representatives from your compliance team, for example, from a legal team perspective, who will, like Khushbu said, go into speak to each of your suppliers, look at their contracts. You would need somebody from an IT team who would look at how you store data. You will need people who understand how much data retention is required. You would need to involve your marketing and sales team, because they would need to stop sending those emails. You would need to go back to the drawing board to see how would you do ad tech, for example, right? So it's the entire organization. You would need to create like a steering committee to drive this, who will take these steps to implement about 60% till we get the rules, which as per the public statement should come in about a month or so.
Thank you, Jaspreet. I think that was very useful. And I'm cognizant that we are sort of running out of time. So I would like to thank all our speakers today for being here and for sharing your expertise and knowledge. It was indeed a very illuminating and very interesting session we had today. I'm sure that, in subsequent sessions, we can explore more in depth about this topic of, data privacy and, how to implement. I think it's complicated enough, as we have learned today. My thanks also to all the delegates, who attended the session and you posted your questions. I hope most of your questions have got answered. I'm sure there are a few which have not got answered. I think we are still looking for clarity from the government about, how to implement the rules and, what that will imply for your own businesses. I encourage you to, remain in conversation, with each other and with us, so that we learn as we go along. But please do, fill out the feedback form. We would like to have your comments. It will enable us to organize more such sessions in the future. And the link to that form is being posted in the chat box. So you please do fill out that form. My thanks once again to all the speakers and to everyone who have attended this session. I'm very gratified that, over 100 people are still there, attending this session, despite, it having extended so long. So thank you so much once again. And I look forward to seeing you all on another occasion. Meanwhile, it's goodbye from the CTO Forum, and have a great day.
Thank you, everyone. Thank you
so much.
Thank you.